Under Rule 301 of the Federal Rules of Evidence, or FRE, a party in a civil case against whom a presumption is directed generally has the burden of producing evidence to rebut the presumption. But what if there are two conflicting presumptions? May one presumption be offered as proof to rebut the other presumption? The United States Court of Appeals for the D.C. Circuit considered this question in Legille v. Dann. On March 6, 1972, Edouard Legille filed 3 patent applications in Luxembourg. On August 11th of that year, he filed a 4th application. On March 1, 1973, Legille sought to file patent applications for the same 4 patents he applied for in Luxembourg in the United States. Legille's attorney mailed 4 patent applications from East Hartford, Connecticut, to the U.S. Patent Office in Washington, D.C. The package was addressed correctly, marked airmail, and had sufficient postage. At the time, airmail from East Hartford to Washington, D.C. normally took 2 days. However, the applications were date-stamped on March 8, 1973. At the time, U.S. patent law provided that a patent application filed within 12 months after filing for a foreign patent on the same invention was given the foreign patent's filing date. Consequently, due to the March 8 timestamp, 3 of the 4 applications were denied because they hadn't been received within 12 months after the foreign patent applications. Legille then petitioned C. Marshall Dann, the Commissioner of Patents, to reassign the filing date, but the petition was denied. Subsequently, Legille sued Dann in federal district court and sought a declaratory judgment that the applications were received on or before March 6th. Specifically, he argued that there was a rebuttable presumption that properly addressed, stamped, and deposited mail would reach the addressee in due course and without delay. In response, Dann argued that there was a rebuttable presumption that mail received is properly timestamped on the actual date it's received. Both parties then moved for summary judgment, and the district court found in favor of Legille. The court held that the strong presumption that properly addressed mail reaches the addressee in due course and without delay may only be rebutted by proof of specific facts, not by invoking another presumption. Dann appealed to the United States Court of Appeals for the D.C. Circuit.